Download our complimentary guidebooks, checklists, and other useful financial resources at savantwealth.com/guides.
Good afternoon, everyone. Good to be with you all at 2 p.m. my time in the afternoon. Glad to have you with us for today. My name is Joel Cundick. I'm a financial advisor in Savant's DC Metro office, and I'm joined today with Alaina Davalos, who is a wealth transfer specialist and really the real expert on this call down in our Atlanta office. So it's good to be with you today.
Thank you to everyone for having us. And Joel, thank you for having me. As you mentioned, I'm a wealth transfer specialist in Atlanta. Before that, I was a practicing estate planning and probate attorney in private practice. So I'm pretty familiar with this topic, and I'm glad to be here to talk to y'all about acting as an executor.
So the first thing we want to talk about with estate planning is just what a balancing act it is. All right. An estate plan is a matter of trying to figure out, number one, what your wishes are. Number two, what your heirs can handle, and what protections might need to be in place for them. You want to preserve your own independence, but you also want your instructions set in stone as much as possible so people don't change them. You're looking to minimize taxes, both income and estate taxes. And then, man, I mean, if we have the secret for preserving family harmony, I think we'd have a lot more money than we do. But we're going to do our best to help you preserve family harmony. Talk about how to do that as you go through the estate planning process. Okay. So that's our framework for today. What we know we want to cover first is, let's get into the meat of what probably brought a lot of you here today. Was what is the role of an executor? What are the steps of the things that they need to take care of? And what is the role of a trustee, which is a different role from an executor, but a very important role in estate planning. And I will turn that over to the expert, Alaina, to help us out there.
Thank you, Joel. So before we dive into those details about serving as an executor, I do want to give y'all a reminder that estate planning, probate, trust, they're all subject to state law. So while we're going to talk generally about these topics, please know that you should also consult a local attorney before engaging in any of these activities. And so now let's start with the basics. What exactly is an executor and what is their role? So I found throughout my time in private practice that most people's perception of an executor and the probate process generally comes from TV. On TV, there's usually a gathering of the family in the lawyer's office. Everyone is waiting with bated breath to see what they're going to inherit. The executor is announced, not who the family expected, and it's all very dramatic. It makes for great TV, but it's not reality, shall we say. Usually there's not a spectacular event. A person who passes away is called a decedent. The decedent either had a last will and testament or they didn't. If they did have a will, it most likely named someone as the executor. The will also, just so y'all are aware, may refer to that person as a personal representative or an administrator. For our talk today, as the title of our webinar suggests, I'm going to use the term executor. So for the family to first find that will, it's usually with the decedent's personal effects in a safety deposit box, or it's with the drafting attorney. Most wills today are written in modern English and are relatively easy to understand. Sometimes there is a lot of language in the document. I myself was known to draft a 50-page will on occasion, but identifying the nominated executor is usually pretty easy. So the executor is not automatically in power. And let me repeat that. Just because someone is named in the will as the executor does not mean that they immediately have the authority to act on behalf of the decedent's estate. Why? For starters, the decedent may not have a probate estate, meaning that there may not be any assets that the will controls. A will, and hence the executor, only has authority over assets that were in the decedent's name alone at their death, or directed to the estate via beneficiary designation that specifically designated the estate. The will does not control assets that had a joint owner or a beneficiary designation that was someone else. Common probate assets include real estate owned in the decedent's name alone, checking and savings accounts with no PODs, which stands for payable on death, and brokerage accounts. This is not a complete list by any means, but these are the most common probate assets. So let's say that the decedent had at least one of those probate assets in their name at their death. They also had a last will and testament. How does the executor then gain their legal power? As I mentioned, this area of law is state specific, so each state has their own rules and regulations about what has to be done to get that executor their power, which is called the probate process. The American Bar Association defines the probate process as the formal legal process that gives recognition to a will and appoints the executor or personal representative who will administer the estate and distribute the assets to the intended beneficiaries. Generally, the decedent's heirs at law and the beneficiaries under the will have to be notified and given the opportunity to object to the validity of the will. If there are no objections, everyone agrees, the court will issue the executor the legal documents authorizing them to act. Please note also, the court may require the executor to post bond based on the projected value of the assets in the estate, file an initial inventory, and provide an annual accounting every year that the estate is open. So make sure you know that could happen. Once the executor has those legal documents, you can see here on the screen the usual process. The executors filed the will with the court. Now they've got to administer the probate estate. They've got to collect the bank accounts, get appraisals on the real estate or list it and sell it, notify business partners of the death. It all depends on what those probate assets are, what the executor is required to do to collect them. The executor also will be responsible for paying any final death, any expenses, paying off the creditors, anyone that the decedent had an obligation to. That includes funeral bills, costs of administration such as legal and CPA fees, and taxes. The executor is legally responsible for filing any final tax returns that are due, which I'm going to talk about in detail in a minute.
Alaina, I've got a question that I think it would be on people's minds. How about IRAs? I mean, our 401ks, those are pretty common assets that people hold. Are they considered part of the probate estate that the executor is in charge of?
So IRAs and 401ks almost always have a beneficiary designation attached to them. Most oftentimes, there's a primary beneficiary, which would be the spouse, and then there's a contingent beneficiary, which often descendants, trusts, whatever fits into that person's estate plan. Sometimes, however, there is no beneficiary. For some reason, the beneficiary designation has failed. At that point, those assets may revert to the estate. And at that point, the executor would have control over them and it would become a probate asset. So that's always part of the consideration when you're looking at what are the probate assets and what does the executor have access to. Because once the executor has finished collecting all these assets, no matter where they came from, what they had control over, they pay out the debts. Then it comes time to make distributions to the beneficiaries. With a will, those beneficiaries are going to be very clearly laid out who they are, who is receiving the probate assets. It can be sometimes it is, sometimes it isn't, to make those distributions to get everything figured out. Once all of that has been completed, however, once all these steps have been taken, the executor can formally close the estate. And closing the estate generally releases that executor from any further liability related to their role as executor, meaning creditors can't come after them, beneficiaries can't come after them. They have hung up their hats. They said, I'm done, I'm leaving, don't spend your inheritance all at once. And that's what a lot of executors want to have happen because they don't want to be on the hook for the estate forever. And so while this sounds relatively simple, and it can be, executors, being an executor can get a bad reputation because there are some things that make it very difficult. And family conflict can make this a very difficult job. Taxes and unusual assets like business interests, oil and mineral rights, out-of-state real estate, those can make this a very difficult job. With good planning, though, the executor can be a short-term role that keeps the family harmony and sufficiently and succinctly distributes the decedent's assets. On the flip side of the negativity, there is some positivity, and that is that the executor can get paid. So either the will or state law will dictate what the executor is entitled to for taking on this position. So for those of y'all that are in the process of doing your estate planning, or those of y'all that are acting as an executor now, make sure that you are aware how much the executor is entitled to from the estate. So there is one other aspect that I want to talk to you about to make sure that y'all understand. You know, the other role that we hear about a lot that clients often have questions about when looking at executors and probates, and a lot of clients use these terms intermittently, is a trustee. A trustee and an executor are both very similar and very different. So a trustee is someone who holds assets in trust for the benefit of a beneficiary. A trustee is not usually nominated by a will. They can be, but they're usually not appointed by a court, but they can be. A trustee is named under a trust agreement. And for our chat today, I'm going to just refer to a revocable living trust, not an irrevocable trust. A revocable living trust is a tool that is created by a person called the grantor or the trustor to hold assets in trust. Generally, the grantor is the initial trustee, the initial beneficiary, and the trust uses the grantor's social security number, so there's no income tax consequences to using this sort of trust. The primary purpose of a revocable living trust is to avoid probate at the grantor's death, to take all of those assets that would have passed under a will and been controlled by an executor, and to move them into a trust to instead be controlled by a trustee. Because unlike the grantor, who's a human, the revocable living trust does not die. So the assets that it holds do not need to go through probate. The revocable living trust is then funded in one of two ways. Either during the lifetime of the grantor transfers assets into the name of the trust, or at the grantor's death via the probate process or a beneficiary designation. That's right. Sometimes an executor will have to go through the probate process in order to transfer assets to a trustee. A lot of times, the executor of the will, which when you combine it with the revocable living trust is called a pour-over will, and the trustee of that same revocable living trust are the same person. You know, that makes for a smooth transition of assets if the pour-over will needs to go through probate. So the trustee's role, like I said, is very similar to the executor's. The trustee is responsible for administering the trust and collecting the trust assets, whether that's from probate, whether that's from a beneficiary designation. The trustee then pays any taxes, debts, or administrative fees not paid for by the executor. However, sometimes a revocable living trust will not end. Instead, it will morph into an irrevocable trust at the grantor's death. In the graphic you see here on the screen, we've got a revocable living trust that changes into a trust for the survivor, which in this case means the surviving spouse. At that surviving spouse's death, the trust changes again into subtrust for the children. Those children's subtrusts are generally irrevocable. If that is the case, if the trust fund is not simply paid out to the trust beneficiaries, then the trustee has additional duties. They'll continue to manage and invest the trust assets on behalf of the beneficiaries, approve any distribution requests, and file any annual trust income tax returns that are needed. They'll also make any mandatory distributions that the trust agreement dictates. A lot of times we see those mandatory distributions for younger beneficiaries. It would be set up so that 1/3 of the child's trust goes outright at a certain age, let's say 25. Half of the trust goes outright at age 30, and the balance goes outright at age 35. Whatever the trust says, the trustee must do. So as opposed to being the executor, which is a relatively short-term position, being the trustee can be a long-term duty. So if you are nominated as a trustee, or you know that at some point you may need to act as that trustee, make sure you're aware of that fact, that this could be an ongoing role. So the other reason why it's important to differentiate between these roles is because they're controlled by different documents. The trustee is subject to the terms of the trust agreement, and the executor is subject to the rules of the court and the terms of the will. So if you're in these roles, make sure you know which document is controlling what you can and can't do. And finally, everyone's favorite topic, which is taxes. Whether the role is as executor or as trustee, there are a few important deadlines when it comes to administering a decedent's estate. The first is going to be when the decedent's final income tax return is due. As I'm sure most of you know, that's April 15th of the year following the decedent's death. It's the same as you and me. That deadline, again, same as us, can be extended to October 15th. That same deadline rule also applies for an estate income tax return. So that has to be filed if there's any income earned by the decedent's assets after their death, but before they're distributed to the final beneficiaries, so long as it exceeds a certain threshold, which is currently $600. So if the estate assets don't generate more than $600, they generally don't need to file an estate income tax return. There is also a trust income tax return. So when I mentioned those kids' subtrusts that are held for a certain term of years or potentially for a lifetime, every year that trust generates more than $600 of income and it's not distributed out to the beneficiary, the trust will also have to file a trust income tax return by, you guessed it, April 15th. Magic number for those income tax returns. There is, however, another tax return. So many tax returns. And this one is filed by the executor or trustee, and it is a federal estate tax return, which is the 706. So this return is not due on the calendar year. Instead, this return is due 9 months after the decedent's death with an available 6-month extension. So you generally have 15 months to file that estate tax return if it's needed. It's important if you're in that role and you think an estate tax return is going to be needed, to make sure you write down those deadlines and get those returns filed by the deadline. The IRS is not a creditor that you as an executor or a trustee would like to mess around with. And I'm sure your CPA and attorney will agree on that one. So generally, an estate tax return is required when the decedent's assets at death, their wealth, combined with any lifetime gifts that they made, exceed the decedent's available estate tax exemption amount in the year of the decedent's death. This year, that exemption amount, which is controlled by Congress, is $13.61 million. So I wish every client an estate tax problem. So it's a great problem to have. However, that amount is already scheduled to sunset with the sunset of the Tax Cuts and Jobs Act from 2017 at the end of 2025. That estate tax exemption is going to go down to about $7 million per person. While it's still a very high number, it is going to impact a lot more Americans than there are today. And the way that tax is calculated is it's 40% of all wealth over the exemption amount. The other thing that y'all should know too about filing a 706 estate tax return is that you may need to do it to make a portability election. What is portability? So portability is when the decedent's available estate tax exemption is ported over to their surviving spouse. So if the client who passed away has $7 million, they can transfer that $7 million of exemption amount to their spouse. When the spouse passes away, the spouse has a combined $14 million of exemption. This can be beneficial because it can allow the surviving spouse to give more assets to beneficiaries at their death without having to pay additional estate taxes. If the decedent's estate only needs to make a portability election and the estate does not owe any estate taxes, there's a new 5-year rule that allows the estate to make that portability election. This is a very recent change in the tax code. So if you or someone you know, if their spouse died within the last 5 years, seriously consider and consult with your advisors whether filing a 706 to make a portability election would be a good idea for your estate. And last, more taxes, less IRS. There can also be a estate tax exposure. Georgia, Virginia, where Joel and I are based, there's no estate taxes, but Savant, based in Illinois, there are Illinois state estate taxes. So make sure that you consult with your attorney and CPA if there's going to be state taxes due. What is the deadline for that filing?
And I happen to live in Maryland, though I work in Virginia.
Oh.
And Maryland has the blessing of having both an estate tax of 16% and an inheritance tax for non-lineal descendants. So just an example of how broad a variation there can be here in the States. And I typically tell my Maryland clients if they want the number one piece of estate planning advice I can give them, it's move out of Maryland, which most don't want to do, but that's okay. So I'm going to cover, thank you very much for that, Alaina. The very thorough coverage of trustee and executor roles. I'm going to talk a little bit more now. We're going to shift to the design stage, and that was another major area that people on this call are dealing with. And I'm going to talk to you about the important documents to have when you prepare an estate plan and why each of them needs to be in there. Okay, and maybe some caveats as you prepare them. The first that I'll mention actually has to do with, these first two have to do with when you're alive, not after your death. But we call them estate documents because we're giving power to someone else. A power of attorney for property is a document that, when you prepare it, authorizes someone else to act in your name as if they were you. All right. And there's two ways of doing it. It used to be pretty common that these powers were given on a springing basis, meaning they wouldn't come into effect until somebody was incapacitated. However, now most estate attorneys draft these documents so that they are active. They are living powers of attorney that you have designated somebody who now currently has power to act in your name. Now, it sounds like that's a lot of power, and it is. And as a result, you need to make sure that the person you are authorizing is worthy of the trust that you're giving them. They can enter into loans in your name. They can buy and sell property in your name. They can do a lot related to you without you being there with that document. So something to keep in mind. We want to see at least 3 people named in succession in that document. The reason is we want it to be as flexibly useful as possible. We only name one individual as our power of attorney. That individual happens to be incapacitated, out of the country. We are then, no one is able to transact. And so we want that power of attorney to have at least 3 names in there. We want it to include digital asset authority, which was not even considered 10 years ago on a power of attorney for property. So this means that they could go to social media companies and act in your name because you've specifically given them control over digital assets, for example. We want it also to state that it permits the power of attorney to transact on retirement accounts and retirement plans. So IRAs, 401ks, what have you. If you do not name specifically in that power of attorney that this individual can act on your behalf for those accounts, you can be in a situation where it's always up to the institution, right? You will present this power of attorney to the institution. The institution will present the power of attorney to their legal team. The legal team will review the document to decide whether they want to honor it or not for what you're wishing to transact. This is one of the reasons, looking back to what Alaina was speaking of earlier, why you might want to use a trust instead of a will in certain cases to control distribution of assets. Because if you're a successor trustee, it's not up to a legal team. It's up to the attorney who drafted it initially. And you have the authority to act in that person's name once you provide whatever certification you need to that the primary trustee is disabled or incapacitated. So that's one document, power of attorney for property. Then we want a power of attorney for healthcare and an advanced medical directive. This, in most states, has been combined into a single document. You used to hear of a power of attorney for healthcare and a living will. In most states, you can just do a single document for this. And what you're doing is you're stipulating what you want to have happen in case you can't make decisions about your health. And if the situation affecting your health is not listed in the standard scenarios you've kind of indicated, well, here's what I want to have happen, you indicate someone else who can make healthcare decisions on your behalf. When you enter into a hospital these days, they will always ask this: do you have an advance directive? It's a good thing to give a copy to your primary physician. It's a good thing to have a copy at home. And if somebody's needing to go into the hospital to go under surgery, something like that, to bring that along with them, because this is, again, a powerful document that gives someone else the authority to act in our name when we can't act for ourselves. So those 2 documents, not too difficult to draft, sometimes difficult to decide who you want to be in those roles, but very important to consider. Then we have 2 other,
Can I chime in for you real quick?
Sure, absolutely.
Sorry, Joel. One of the things that I always want to emphasize to our clients, especially about these powers of attorney, is for young adult children. So if you have teenagers that are all of a sudden 18 or 19 years old, please know that your ability to communicate with their doctors, with their advisors, whoever is working with them, is now almost completely restricted. They are adults, and the only way that you may be able to talk to doctors would be via a healthcare directive, something like that. So make sure you consider talking to your adult children about it.
It's an excellent point, Alaina. One that I learned of when my freshman in college daughter had emergency appendectomy halfway across the country from me. So this is that, the doctors would not communicate without that document. You may still view them as your kid, and they will be for life. But once they're 18, the law dictates that you don't have any ability to know without them giving you consent that you would know what's going on with their health.
Exactly.
So two other documents we're going to talk about here. One, everyone needs to have. Another, is a decision that Alaina has already kind of covered in good detail. Let's talk about the last will and testament. Do people need to have a will? Yes, everyone should have a will. It's the only document that can name an executor. If you do not have a will, then your assets that are not divided by beneficiaries are going to pass by what's called the intestate laws in the state that you live in, which means there's predetermined people who will inherit assets when you have not stated it. And I like to tell clients, the worst decision that you're going to make of how you want to transfer things is going to be better than the best decision the state's going to make on your behalf. So please designate who is in control, who's going to be your executor. It's also the only document that can name a guardian for minor children. So if you have children under the age of 18, another reason it's critical to have a will, because again, if you do not name who is the guardian, that's going to become a matter for the state and the courts. All right. As Alaina referred to, many wills will just pour over into a revocable trust, and that kind of transitions us over to that. You don't need to have a will to designate how anything transfers at your death. If you just point it to the trust, you transfer your IRAs by beneficiary, you transfer your life insurance by beneficiary, you transfer real estate by titling potentially. You can name a pay on death or transfer on death that acts like a beneficiary to an IRA in a taxable account. So, but the revocable living trust is going to help us avoid probate. It's going to make sure that assets don't go through the state's control first, state supervision first, and it's going to give ongoing asset protection for our beneficiaries. And then we will have continuity in the financial management of our assets in health, in incapacitation, and after death. The revocable living trust covers you throughout that time period of who is going to be in control. All right. As to whether you need a trust or not, it highly depends on the state that you live in and the form of your assets and intentions after death. But I will say, like for our clients in the state of Virginia, we strongly recommend having a revocable living trust just because the probate process is so prolonged in that state. Maryland, not as near as big a deal for that, a much faster probate process. So that's going to depend on the state that you live in. Those are the 4 key documents, 3 absolutes, 1 optional, that you need to have as you draft an estate plan, and why.
So another important aspect of just looking at your estate plan overall and trying to make things as easy for your executor, as easy for your beneficiaries, is going to be aligning your documents, your will, your revocable trust if you have one, and your beneficiaries and your asset titling. So here is a sample estate plan, similar to what Joel just discussed. And I do hope you guys like this chart because this is what I normally spend my time here at Savant doing every day for our clients, which is reviewing documents and preparing graphics like this so that our clients can see how their estate plan is going to flow as a cohesive unit. So in this example, we have a joint revocable living trust. It has been funded with some assets already. So these clients moved a brokerage account, the trust fund, and they moved their home into the name of the joint trust. They do still have some assets that are going to pass outside of the trust. They've got joint assets. They've got a bank account and they've got EE bonds. Those are held jointly. They'll pass to the survivor. If something were to happen to this couple simultaneously, those would become probate assets. We've got life insurance here. life insurance on client 1. It names client 2 as the outright beneficiary. What that means is client 2 is going to take the proceeds from that policy into their name, into their personal estate. They are not going to be used to fund those marital trusts that you see here. We've also got the qualified retirement accounts, the IRAs and the 401ks that are going to pass via beneficiary designation. So this, when we're looking at the overall estate plan when someone has passed away, this is also where I see a lot of family disconnect, because a lot of times family members that are unhappy with how something has happened will blame the executor or trustee. For example, let's say of how the IRA is passed. Well, unless the estate or the trust is named as the beneficiary of those accounts, the executor or the trustee has no control over them. Any issue that resulted is because of poor planning on the decedent's behalf. And well, they don't care at that point. They're dead. They've left this mess. And so going back to this graph, this is a relatively complicated trust that we've presented here with these spousal subtrusts, with these lifetime trusts for the children. And if you've worked with your attorney to come up with this plan, that's step 1, getting those documents in place. And you'll see, step 2 is trying to figure out those beneficiary designations. And as Joel mentioned before, with IRAs with qualified accounts, which do make up a significant portion of most Americans' estates, there are several options for who to name as the beneficiary. Joel, can you talk a little bit about how those will work? What makes for a good or a bad beneficiary?
Yeah, absolutely. I mean, what we want to be careful of, I typically tell clients what I want to hear first is what are the outcomes you're looking for? And then let's back into how to leave assets in a way that accomplishes your goals. So I'll give you an example, that's a little bit prior to this screen about leaving IRAs to heirs. IRAs are ideal to leave to charities because other assets that I transfer to my heirs may not be subject to taxes. A traditional IRA left to my children or any other heir will be subject to income taxes. It's called income with respect of a decedent, and they will have to pay taxes. If I leave my IRA to a charity, then the charity doesn't pay tax. So I actually would rather, for example, not have, hey, 10% of my trust goes to charity, 10% of my IRA goes to charity, 10% of my bank account goes to charity. I'd rather actually carve out and say more of the IRA goes to the charities and the other assets pass to my beneficiaries. So that's one thing we want to watch for. If we have charitable intent, let's guide that decision towards our IRAs in most situations. If I name beneficiaries, my children, my spouse, outright as inheritors of my IRA assets, that's pretty simple. Okay. The custodian is going to ask for the information about each of those beneficiaries. They're going to provide their date of birth, their social security number, their address. The custodian will open up a beneficiary IRA or inherited IRA in their name. It will have different rules than a normal IRA, can't be combined with other IRAs. There's no asset protection when I've done that, though. So they're going to get that asset. It's in their name only, and now they can spend it how they wish. And sometimes clients we're working with who are trying to accomplish distribution with control, but have major IRA assets, have this loophole where they think all of their assets are protected and covered. But in fact, some of them are going outright to heirs. And so we want to potentially use a trust. The trust leaving, you can't yourself, you cannot title your own IRA into a trust, but you can leave a trust as a beneficiary of your IRA. That definitely adds complexity, but it protects assets better. It makes sure that when your children or grandchildren inherit the assets, they cannot have complete control over those assets immediately, but rather get distributions over time according to the instructions you've left in the trust. The flip side to that coin is that that's a potentially less income tax efficient way of leaving assets to children. It can trigger an accelerated tax where you might have had 10 years to leave the asset over which they take the IRA, and now they might have 5 years. It also can create a situation where you are paying inside the trust, if you're not careful, very high tax rates. We want to see income distributed out of trusts. Lots of people don't know this, but all of the tax tiers that you're aware of, brackets, they're completely different rules for trusts. Once you cross basically $20,000 of income in a trust, you're at the very top tax rate. So these are things that we want to watch out for when we're considering leaving IRA assets to our heirs in trust. Not saying we don't. It's just say that we should know the implications. And as a result, it's why it's so helpful what Alaina showed in the earlier slide, seeing how all assets transfer, because then that gives you the space to ask the right questions. Okay. Yeah, this is just great. Now we can talk through this. All right, look at how different assets are transferring here. You can see your trust and home in the middle are transferring in your trust, but your IRAs over on the right side are transferring to clients directly. Now we've named the trust as a contingent beneficiary. How will that work at my death? And we can have a conversation about that. All right. So when do you want to leave?
Joel, can I interrupt again? So sorry.
Always.
What are those conduit provisions? How do those work?
Yeah, so I think we got another slide. If you skip one more ahead, we'll talk about that. So we can have a conduit trust, and this language was much more common prior to the Secure Acts of the last couple of years. That really did change a lot about how people inherit. An inheritor used to be able to have a stretch IRA over the entirety of their lifetime. Now they're limited to take out in 10 years. So a conduit trust would have said all withdrawals from the IRA have to be transferred to the beneficiary of the IRA. So if I need to take $100,000 out of an inherited IRA, all of that has to be given to the beneficiary. All right. So conduit trust just says, yeah, it's a trust, but as income distributes, I want them to get all of it. Typically a fine way of leaving assets. However, sometimes I don't want my inheritor to get assets outright. I still want to control it in trust because those distributions are larger than I want to make, or because my beneficiary is receiving state benefits, for example, they're disabled. And if they receive that much income directly, that would be problematic for them for the benefits they're able to access from the state. Then I want to use an accumulation trust. The accumulation trust is going to keep IRA distributions inside trust. So you have an inherited IRA titled to the trust. You have a taxable account titled to the trust. The distribution from the IRA goes into the taxable account titled to the trust. That's probably going to trigger much higher taxes because it's going to be taxed at the trust tax rate. However, there are situations where you're going to want that to happen anyway. And it's important to stipulate in your trust how you want that trust to function as a conduit or an accumulation. All right. And like I say, Secure Act changed a lot of these things. So you may go back to your estate attorney who you worked with 6 years ago. They might review your documents and say, yeah, we actually want to make some substantial changes to how this trust functions as a result of recent tax change. So when do you leave it in trust in your IRA? Like I said, if it's a substantial IRA balance and you think the beneficiary would not be able to handle it, or you're concerned about asset protection, like the spouse of a beneficiary getting access to it, or the spouse of a beneficiary is in a high risk profession where they might be sued. These are reasons you still want to use the trust to control. And really you are weighing pluses and minuses. The plus is greater asset protection. The minus is higher income taxes. And you have to know the details of that for your situation, your state, in order to properly to make that determination. Is there anything you'd add there, Alaina?
No, I think you covered it pretty well. I think one of the biggest points to emphasize what you just said is that the Secure Act changed things. That was 2017, 2018, and they are still making changes to those laws today. They're always providing more information. And so it's very important to stay on top of what your documents are saying and whether they are going to be implementing what you want to have come into effect.
Very well said. Totally agree.
Thank you, Joel. I've talked to many people about this before. So the last thing that we have to talk about is just, I think this has come up in what I've said, this has come up in what Joel has said, and that is the idea of family harmony. So the executor, the trustee, when you're acting in these roles, your family is going to be looking to you as that sort of person that is keeping everything together. Whoever it was, let's say it was your parents. They nominated you to be the executor. They nominated you to be the trustee to take care of things. And that takes on a lot more, there's a lot more than just financials at stake, right? Because it's also trying to figure out how your family is going to move forward after the loss of a patriarch or matriarch. Joel, do you have any advice on how to handle that, or if you're in the midst of estate planning?
Yeah, well, I think the biggest consideration to keep in mind is, as aspirational as you might be on how your heirs will handle things, you have to plan for them trying to handle things at one of the most stressful times of their life. So a lot of family fissures that otherwise kind of get glossed over really are evident at the time of an inheritance. The best thing I've seen to mitigate that is, well, two things. One is to contemplate what could go wrong, right? Think of not just what you're intending, but how it might be received by the heir. That is a great thing to put a lens to how they're going to be thinking of things. And the other is to communicate. One of the things I love doing with clients is to have an intergenerational family meeting where we talk about the estate plan. I know we kind of want to keep cards close to our chest, but this is one of those situations where open communication oftentimes can head off disagreements that would otherwise potentially cause rifts in families for many years to come. So I like to see clients be very thoughtful in the way that they design the plan, think of all stakeholders, but then have a conversation with them. If they're disinheriting a child, probably better to let them know that in advance, right? If they are leaving assets unequally, we talk about ethical wills, right? Where I have one child who is an attorney, another child who is a teacher, and I decide to leave more assets to the teacher than the attorney. It's really important to communicate. My money is not a reflection of my love. My love for you is both equal, but we're trying to leave assets in a way that will be of most benefit to our future generations. When you have that conversation, that heads off potentially years of resentment and hurt that otherwise, they just didn't know what you intended. So these are the kinds of things we'd like to see happen: communication and thinking from the perspective of the inheritor.
That's great. Thank you, Joel. So thank you guys all so much for joining us today. I invite y'all to schedule an introductory call to see if there's any further questions or if there's any way that Savant could help. We'll get you connected with a Savant advisor who can help guide you on your journey.
Yeah, we've had a number of questions come in. There was a large attendance today, and we're really grateful for it. It means that we are not going to be able to get to all questions. We're going to handle a few. I've tried to kind of go through and pick up most of the themes. But importantly, if you post a question in there, you're going to get an answer, right? It might be Alaina or me. It might be somebody else on the team, but we're going to make sure we get you an answer to the questions you posed if we don't cover them on the call. But let me see here. All right, all right. What are some common pitfalls that executors deal with? Is that something you can talk to, Alaina?
Yeah, for sure. So I would say some of the biggest issues that executors run into are what we just discussed. difficult family situations. And I will say the worst family infighting that I saw in private practice was over stuff. Siblings could be inheriting millions of dollars and they would fight over who is getting the silverware, who came and took the car, things that it was so hard for me to see that these families, even with good estate planning, you do run into these issues and the executor has to deal with them, that families could be ripped apart over stuff. So that is one of the biggest pitfalls. The other one that I see is, especially with executors, the amount of time and legal costs. The longer that an estate is open, the more fees there are going to be. Legal fees, CPA fees, filing all those income tax returns I talked about. And so the better job that an executor can do to get things done, get things distributed out, it's going to pay off in the long run.
Yeah, and I've seen that. I mean, if a well-designed estate plan transfers much faster, right? If people have contemplated this in advance,
Yeah.
things go more smoothly. If people have talked in advance, to your point about stuff, there's an idea already of, hey, what might be the stuff that people are going to care about, and they've talked about what will happen there. Very helpful.
And
All
like
right.
Joel said, the best thing to do is to have those open and honest conversations, with your kids, with your siblings, whoever you think is going to be impacted by this. Just talk about it.
Yeah. Yeah. All right. Another one here is it better to have a will-based plan or a trust-based plan? And I would say that you can go either route. The route that you determine is largely dependent on the state, as we talked about, and your intent. So that really needs to be discussed with your attorney. But I will say the biggest problem you can run into is when you think you have a trust-based plan and you have a will-based plan. And when would that happen? It happens when, I mean, this is one of the things we think is so critical with clients. You'll sit with an attorney, you'll draft an elegant trust. It's written up just the way that you want things to go. And then your assets aren't titled into the trust. Just because you wrote up a trust does not mean the trust owns anything. And so where we'll try and work with clients is we'll get the plan, we'll look at the assets, and we'll say what changes need to be made to IRA beneficiaries, to ownership of houses and investment accounts to get things in line with the plan. So either one can work, will or trust, but we have to make sure assets are titled properly. Okay. I think we have time for one more. Okay, Alaina, how expensive? You kind of said that there's fees, but tell me, how expensive is it to go through probate?
So again, my very vague attorney answer is that it depends. Fees will accrue for filing the probate petition. There are fees for hiring an attorney. Some states, those fees are dependent upon the assets. So in certain states, the attorney can charge a percentage of assets as opposed to an hourly rate. If the estate is very complicated, if there are multiple business interests, if there's real estate, the more stuff and the more random stuff, the more expensive those fees can be. Also, on top of that, like I mentioned when we were talking, is the executor's fee. The executor's fee is very often based on the assets that are held within the estate. So here in Georgia, it's 2.5% in, 2.5% out, which is about 5%. And then the executor usually can go to the court and say, hey, I've done a lot of work. I've managed this real estate. I have taken care of all of these things. I would like additional fees. So those are probably the two biggest fees, is the legal fees, the executor's fees. And the CPA fees can get pretty substantial too, especially if a 706 is due with estate taxes. The portability election is usually not as much because not as much information is needed, but don't quote me on that and make sure you get a quote from your CPA before you go down that road. But I would say it can cost anywhere from $2,000 to $100,000. I have seen some very expensive probates.
Yeah, and
And
this
some
is one of
cheap
those
ones.
places that I think it's really important to talk through. People get concerned about paying for an estate plan,
Mhm.
and you can pay at different points. It's better to pay for a well-drafted estate plan. It's less costly to pay for a well-drafted estate plan and for everything to flow smoothly from a time and money perspective than it is to do a half-baked estate plan that then involves a lot of work for a lot of people after your death. So I would say you are going to pay to get these assets to transfer properly. And that's a good thing, right? Because you want them to transfer that way and may save time and money for heirs. One
100%.
corollary to that, Alaina, that I've seen in the questions here that just would love you to speak to is what if all assets are transferred outside the will? Like what if you've got transfer on death and IRAs to beneficiaries and everybody gets assets? Who gets paid if there's a creditor of the estate?
So that's a very hard question to answer. And that is also a very state specific question of what creditors' rights are. Generally, in that situation, what would have to happen is the creditor themselves would have to open the probate estate. Then they would have to try to collect against those outside heirs. The biggest issue with that is that information may not be available. They may not know even that the decedent had a retirement account, let's say with $1 million in it, that got distributed outright. It makes it a lot, creditors are a lot less incentivized to try to open that probate estate because it could all be for nothing.
Yeah, yeah, that makes sense. And so this is really territory where it's good to talk with somebody, an attorney in your state, to determine what those rules are. If you're dealing with it now or you're contemplating potentially dealing with it, it's good to understand. And I love that these are what if questions that people are bringing up here. So
sure.
that's the time we had for questions today. We really enjoyed being with you this hour. Please, if you feel like there's something in your situation that you'd like help with, a specific question, go to our website, schedule a 15-minute consultation with us. We're happy to have a conversation with you. This is what we eat, live, and breathe. All right, we love all the whole discipline of financial planning, but specifically estate planning matters to us as well. So thank you for your time. We will get back on whatever questions were posed that we didn't have time for, and we look forward to being with you again soon.
Thanks, y'all. Have a good day.
Download our complimentary guidebooks, checklists, and other useful financial resources at savantwealth.com/guides.